So welcome everyone. Today we have Professor Hanoch Dagan. Hanoch is a well-known name for those of us who work in private law, but for the camera, permit us to say a few things about Hanoch. So Hanoch is the Stewart and Judy Colton Professor of Legal Theory and Innovation and former Dean at the Tel Aviv University Faculty of Law. He is an extremely prolific author, having published, I think in recent times, The Choice Theory of Contracts, and today he's presenting to us liberal theory of property. So over to you.
Thanks so much. It's a great pleasure and a really distinct honor to be included in the 2018 Singapore Symposium in Legal Theory, and I'm deeply grateful for Andrew and Chongping for the invitation and for all of you for coming. And this is also a special event for me, partly because it is the first time in which I present this draft of my forthcoming book, in which I hope to offer, after more than 2 decades of writing on property law, a comprehensive liberal theory of property. There is, of course, a long tradition in Western political thought which connects property and liberalism, and it usually corresponds with the conventional view of property in legal discourse. And property, in this conventional view, is conceptualized around the owner's right to exclude. Blackstone's conception of property as sole and despotic dominion, the famous one, obviously captures the structural essence, according to this view of property, and is also closely related to property's normative task of constraining other people in order to vindicate the owner's independence in setting and pursuing purposes. This orthodoxy of property fails, I argue, however, for both descriptively and normatively. And refining the reasons for its failure is nonetheless important, not only for its own sake, but also because those reasons point to an improved understanding of the intimate connection between property and liberalism, what I hope to develop in this book, namely the autonomy-enhancing account of property. Descriptively, the traditional understanding of property fails because it disregards two constitutive characteristics, two constitutive features of property: the profound heterogeneity of property types and the significant limitations on owners' authority. By obscuring both property's structural pluralism and property's compliance with relational justice, this traditional view, I argue, is also normatively disappointing, because it neglects liberalism's most fundamental commitments owed to individual autonomy, namely to our self-authorship or self-determination. Only by appreciating the ways in which property can, should, and in many respects already does enhance our autonomy can we achieve a genuinely liberal conception of property, or so at least I argue. I will divide my presentation into 2 parts. First, I will argue that property is best understood as a power-conferring institution, one which can be legitimate only if, and to the extent that, the authority that it confers, which enables the instantiation of its intrinsic and instrumental values, empowers us in our ultimate right to self-determination. I will then turn, that will be the second half of my presentation, to the 2 important prescriptions that guide a genuinely liberal property law. An autonomy-enhancing property law must comply, I will claim, with the prescriptions of structural pluralism and of relational justice. So let's begin. Property, I argue, empowers self-determining individuals to pursue their conception of the good, and it is this autonomy-enhancing telos that legitimizes property and shapes its legal contours. This understanding of property as a potent means for enhancing our autonomy is different from property's traditional understanding, which is founded on a conception of freedom as personal independence. But substituting independence with self-determination as property's ultimate value should be natural to liberals, who generally reject the distinct conception of freedom as independence and generally subscribe to this more substantive conception of freedom. Individuals are free when they act on their capacity to have, to revise, and rationally to pursue a conception of the good. This is, of course, John Rawls. As Joseph Raz famously explained, autonomy requires not only a measure of independence accompanied by the appropriate mental abilities. Rather, it is also dependent upon both material conditions and a sufficiently heterogeneous inventory of alternatives. This lesson explains why, in a liberal polity, people are entitled to a system of law supportive of their ability to shape a life they can view as their own, rather than merely one that respects their capacity for uncoerced choice. Indeed, self-determination represents a rich conception of freedom. It makes our independence worthwhile. We are all entitled to be free from coercion because this freedom is necessary for each of us to write the story of our separate, although importantly interdependent lives. Whereas independence is an intrinsic rather than an instrumental value, it is also not the ultimate value. Rather, independence is a constitutive part, or you could call it an essential ingredient of the ultimate value of self-determination. This is the reason why liberals like H.L.A. Hart are unimpressed with Robert Nozick's attempt to, and I quote from Hart, lump together and ban as equally illegitimate things so different in their impact on individual life as taking some of man's income to save others from great suffering and taking one of his vital organs for the same purpose. With Hart, liberals think that the former does not ignore the moral importance of the division of humanity into separate individuals. Therefore, with Hart, they must recognize the significance of the unexciting but indispensable chore of distinguishing between the gravity of different restrictions on different specific liberties and their importance for the conduct of a meaningful life. I'll return to Hart's important prescription later on. Now, private law traditionalists are likely to resist this conclusion. They are likely to invoke the conventional understanding of the public-private distinction, which stands for a division of labor, a division of both institutional and moral labor, between the responsibility of the state to provide a fair starting point for all, and the responsibility of the individual to pursue her ends using her fair share. But this approach cannot work. And it cannot work because even a public law that is committed, as this view prescribed, to redress the pitfalls of a strictly independence-based private law, which is a long shot, but even assuming that it can work, it would still fail given two facts about our human condition, namely our interdependence and our personal difference. These facts account for the profound implications of the law governing our interpersonal relationships on our ability to lead a life, not to mention a successful life. And the law that deals with our interpersonal relationship is private law, of course. If we take the facts of interdependence and personal difference seriously, if we appreciate both the vulnerability and the valuable options to which these social conditions give rise, we must acknowledge that a liberal commitment to individual self-determination cannot be excluded from the law governing horizontal relationships. Although the implications of the commitment to this core liberal value differs between the private and the public domains, setting it aside insofar as private law is concerned is, or at least must be, unacceptable. Therefore, in a liberal society, autonomy must be property's ultimate value. Autonomy, of course, is not the only reason why individuals have property. People have property. Hi, James. They become owners and co-owners. I've already covered all the answers to all your questions, and especially challenges. They become owners and co-owners in order to secure property's intrinsic and instrumental values. In addition to independence, property plays an important role in developing our personhood, constructing our communities, and securing the material resources we need in order to achieve our plans and fulfill our goals. Basing property theory on self-determination rather than independence creates a space to properly address the role of personhood, community, and utility, as well as independence, of course, in the normative infrastructure of property. These values do not work as ultimate, freestanding values of property, as they appear in some property theories, but they are also not fully specified by the abstract notion of self-determination. Rather, because they can be components of or instrumental to the story of our lives, they have their proper role in an autonomy-enhancing system as intrinsic and instrumental values. I'll return to this point when I discuss property structural pluralism. Now, at this point, I want to explain why property should be conceptualized as an empowering device in the service of people's self-determination, and why this understanding of property is key to both appreciating and facing, or at least trying to face, the formidable challenge of property's legitimacy. Consider first the powers of property. Property is not just about provision, although this is also important, of course. Rather, property is first and foremost about having some authority over resources. As Maurice Cohen famously argued, the dominion over things that law confers on owners empowers them in their interpersonal relations, and thus also implies private imperium over their fellow human beings. Owners do not only have the right to control a resource, they also have the authority, the normative power, to determine what others may or may not do with this resource. This is an unusual authority, which requires non-owners to defer to owners' authority to fix their own normative situation. For those others, private property turns out to be a normative threat. Unlike public officials, private owners purport to influence the practical deliberation of others, not merely by way of pointing out to independently existing reasons for action. Rather, they are entitled to posit their own subjectivity as a source of legal claims over anyone else. Subjective non-owners to such an authority, typified as it is by a profound accountability deficit, offends the moral equality that exists between owners and non-owners. This means that the demand for an adequate justification of private property, which Cohen's metaphoric use of imperium sought to emphasize, is even more pressing than Cohen appreciated. This is why the privileged authority property confers on owners implies that property law can be justified only if it can be acceptable to us all, and particularly to non-owners, who are the subjects of this authority. A liberal theory of property recruits for this awesome task property's contribution to people's self-determination. To appreciate this contribution, we need to return to the role of powers in property theory. My previous comments in this regard imply that property is first and foremost power conferring. Indeed, unlike many of our tort law duties, the duties property imposes do not vindicate pre-legal or pre-conventional rights. Rather, they derive from the powers that stand at property's normative core. Property's deference enables normative powers regarding tangible and intangible resources that allow people to have some control, to have a say over these resources in a way that they deem conducive to their own goals. Property may well deserve its role as the keystone institution in a liberal social order precisely because it facilitates people's ability to define and pursue their projects and commitments with some guaranteed immunity from intrusions by the state or by other individuals. A genuinely liberal property law achieves this goal by offering people, for every sphere of human action and interaction, a rich set of acceptable alternatives from which they can choose the optimal balance, optimal for them, of independence, personhood, community, and utility, property's intrinsic and instrumental values. This is how property helps people secure a temporal horizon of action, an horizon of action that they need in order to carry out their projects. Now, property may not be strictly necessary for self-determination, but it doesn't seem far-fetched to conclude that by conferring on individuals the power to invoke these differing types and to employ them in the service of their life plans, property makes a crucial contribution to people's ability to realize the right of self-authorship, at least in the world we know and experience. Now, convincing as they may be, these observations do not yet address the concerns of non-owners. For non-owners, as I mentioned, are threatened rather than served by property's empowering function. I'm not sure that this significant justificatory challenge can be fully met without seriously considering a word that successfully uproots property, which my book does not. It's not clear also what it means to successfully uproot property. But I leave this aside. We can talk about it a little bit in the Q&A if you're interested. But appreciating the ameliorative implications of founding property on self-determination may nonetheless provide at least a preliminary response. Owner's authority, in my account, is founded, as my comments thus far clarify, on a requirement for reciprocal respect and recognition among self-determining persons. This means that this authority must be understood as part of a genuinely liberal private law, one that establishes frameworks of respectful interaction conducive to self-determining individuals. This conception of private law implies a robust prescription of relational justice, which is, as I will argue in the last part of my presentation, the foundation of owners' obligations and burdens, and thus of non-owners' rights and privileges. And these are important features of the autonomy-enhancing conception of property, which do make it much more likely to be legitimate than its traditional Blackstonian rival. And yet, I don't think that they are sufficient. A liberal legal regime that adopts property for the critical purpose of promoting self-determination must also secure the material preconditions for self-authorship. It must rely, in other words, on a background regime that ensures the minimal social and economic conditions, or capabilities, if you will, needed to enable people to become and to remain self-determining individuals. I will say no more regarding the implications of this important proposition for health, education, housing, and welfare policy. Rather, I simply assume such a background regime and want to turn now our focus inwards to explore the proper architecture of property law, that is, to study how it can, indeed should, be shaped to optimally serve self-determination. Now, I begin this inquiry with a seemingly surprising detour to Nozick's Anarchy, State, and Utopia. In the final and understudied part of the book, Nozick conceptualizes utopia as, I'm quoting, a framework for utopias, a place where people are at liberty to join together voluntarily to pursue and attempt to realize their own vision of the good life. A utopia is a place where free people can choose their ends and realize, individually or with whom they choose, their own conception of the good life. To best realize the utopian aspirations of untold dreamers and visionaries, Nozick argues, the liberal state must facilitate voluntary utopian experimentation and provide it with the background in which it can flower. Nozick mentions that utopia requires a variety of all-encompassing communities. But a viable utopia surely requires more than that. Self-determining individuals should be able to choose from not only a range of comprehensive options, but also from parallel sets of options for many more specific decisions they face in various spheres of life. Self-authorship implies not only choosing between life in a capitalist community or a kibbutz, two options that he mentions, But also, and just as importantly, choosing whether we want to live in a fee simple absolute or common interest community, to work as employees or as independent contractors, to do business in a partnership, a closed corporation, or publicly held corporation, and to form an intimate bond of marriage, or rather cohabitate. In and of itself, this refinement does not challenge Nozick's claim that only the minimal state with its libertarian credo can bring about this utopia. One way towards utopia, if this claim indeed holds, would be to substitute our contemporary property law with a much simpler regime, one that includes only two rules. One rule prescribes that owners have an inherent right to exclude. The other rule empowers owners contractually to set up their own governance regime. As long as property is understood as sole and despotic dominion, individuals can, in this view, use their freedom of contract and tailor their interpersonal arrangements so that they best serve their own utilitarian, communitarian, or other perfectionist or otherwise purposes. If this were true, it would have meant that the traditional conception of property is conducive, maybe even essential, to autonomy. But the imaginary reform I've just mentioned is much more likely to undermine rather than serve Nozick's captivating ideal of a framework of utopias. The reason for this is that many interpersonal arrangements, among which autonomous individuals should be able to choose, cannot be realistically actualized without the active support of viable legal institutions or law-like social conventions. A liberal state, which takes its commitment to autonomy seriously, must proactively work through its laws to provide individuals with the broad repertoire of options from which to choose. To see why this is the case, we need to appreciate the insights of both lawyer economists and critical scholars. Consider first law and economics. Economic analysis of private law forcefully demonstrates how many of our existing practices rely on law or law-like devices, legal or law-like devices that help overcome numerous types of transaction costs, such as information costs, cognitive biases, and heightened risk of opportunistic behavior. Merely enforcing the parties' expressed intentions would not be sufficient to overcome the endemic vulnerabilities in most cooperative interpersonal interactions. If many of them are to become viable alternatives, law must provide background reassurances, a safety net for a rainy day that helps to establish or sustain the trust in their routine, happier interactions. Moreover, law's effects are not only material, and here I go to the critical scholars or cultural scholars. Because our private law tends to blend into our natural environment, its categories play a crucial role in structuring our daily interactions. Alongside these material effects, many of our conventions, including many social practices we actually take for granted, become available to us only due to cultural conventions that often, especially in modern time, are legally constructed. So, our private law constructs, our property types and contract types, play an important cultural role. Like other social conventions, they serve a crucial function in consolidating people's expectations and in expressing normative ideals regarding the core categories of interpersonal relationships they participate in constructing. Indeed, contractual freedom, although significant, cannot possibly replace active legal facilitation. Lack of legal support is often tantamount to undermining many cooperative types of interpersonal relationships and thus people's ability to seek their conception of the good. This analysis of Nozick's utopia implies that a genuinely liberal conception of property must repudiate the traditional conception of property. Liberalism rejects the understanding of property as a single, coherent right in which exclusion retains a presumptive moral and legal force. Non-conforming quote-unquote property types should not be understood as peripheral refinements, as they are sometimes described, that are added only if the quote-unquote heavy gravitational pull of property's exclusionary regime is overcome. This core and periphery architecture misses the significance of these property types, which are not only major components of property law's existing landscape, but also crucial components of any liberal property regime. To be sure, property is not, as the bundle metaphor might suggest, a mere laundry list of rights with limitless permutations. Indeed, as the numerus clausus principle prescribes, property law offers only a limited number of standardized forms of property at any given time and place. Understanding property as a formless bundle of sticks open to ad hoc judicial adjustments indeed bears no resemblance to the law of property. On the other hand, neither does the conception of property as a monistic institution revolving around the idea of exclusion. Property can be understood within the exclusion model only if we set aside somewhat arbitrarily large parts of what is conventionally understood to constitute property law. The internal life of property is often structured through sophisticated governance mechanisms, facilitating various forms of interpersonal relationships in ways not possible without such enabling legal infrastructure. Many property rules that prescribe the rights and obligations of members of local communities, neighbors, co-owners, partners, and family members cannot be analyzed fairly through terms of exclusion. While exclusion is silent as to property's internal effects, these elaborate property governance doctrines provide structures that facilitate various forms of cooperative rather than competitive or hierarchical relationships. Furthermore, in shaping the contours of these property types, concerns about insiders' governance may be as or even more informative than concerns about outsiders and exclusion. Attention to the optimal internal property governance is oftentimes an important key to the way property law resolves conflicts between owners and others, third parties. So the notion of structural pluralism takes all this heterogeneity of existing property doctrines seriously. Structural pluralism recognizes the value in understanding property as a category of thinking, given the common denominator of overlapping values and of similar questions in the wide terrain of legal doctrine covered by property. But a structurally pluralist understanding of property is careful not to confuse a category of thinking, which property is, with a category of deciding, which it is not. Structural pluralism appreciates that, notwithstanding the new essentialist attempts to claim otherwise, property's common denominator is not robust enough to illuminate the existing doctrines or determinative enough to provide a significant guidance as per their evaluation or development. Property, properly understood, is neither monistic nor formless. Rather, it is an umbrella for a limited and standardized set of property types which serve an important default frameworks of interpersonal interaction. At its best, this plurality of property configurations, the different contents of owners' rights in these different property types, enables property law to vindicate differing balances among the different intrinsic and instrumental values that property can serve in different social settings and respecting a variety of resources. For this to be the case, doctrinal interpretation and evaluation should, by and large, look to the local animating principles of existing property types, rather than to any quote-unquote core principle of property law. When the law's menu of property types is sufficiently rich, when it provides for each major sphere of human action a sufficient number of options, it offers people a range of meaningful choices that support self-determination. Indeed, a genuinely liberal property law provides what I call intrasphere multiplicity, offering more than one option for people who want, for example, to become homeowners, or engage in business, or enter into intimate relationships. The diversity of alternative property types enables diverse forms of human interaction and association, and thus diverse forms of the good to flourish. Trying to impose a uniform understanding of property on them would be unfortunate, because it would undermine the autonomy-enhancing function of property's structural pluralism. Only a sufficiently heterogeneous property law, alongside a commitment to broad freedom of contract regarding property rules, facilitates a sufficiently diverse set of social institutions, which is crucial for our autonomy. A conception of property fittingly steered by this injunction should emphasize, rather than play down, the existing multiplicity of property law, guiding its expansion to include a manifold repertoire of distinct types in all relevant spheres of human activity. Thus, while at a certain point the marginal value from adding another distinct type is likely to be nominal in terms of autonomy, pluralism implies that law's supply of these multiple property types should not be guided solely by demand. Demand for certain types generally justifies their legal facilitation, but absence of significant demand should not foreclose adoption of these types when they add valuable options that significantly broaden people's choices. Indeed, as long as the boundaries between the multiple property types are open, and as long as non-abusive navigation of these options is a matter of individual choice, the liberal commitment to autonomy does not require the hegemony of the Blackstonian conception of property, otherwise known as the fee simple absolute. Quite the contrary. Rather than channeling everyone to the one possibility privileged by law, a liberal property law must open up options for choice. A structurally pluralist property follows suit, and thus tends to curb law's coercive effects vis-à-vis its monistic counterparts. To be sure, the eradication or even marginalization of the fee simple absolute could entail an excessive restriction of liberty, because it would erase the option of private sovereignty and thus eliminate the option of retreat into one's own safe haven. Independence's intrinsic value prescribes that a liberal polity must offer its members the realm of solitude that such strong ownership represents. But this unique place of Blackstonian ownership, and it is unique, I don't think that it is like any other property type, the unique place of Blackstonian ownership in a liberal property system does not make it is unique, but it is not the core, nor is it the default of our understanding of property. Nor does it undermine the value of other, more communitarian or utilitarian property types. On the contrary, the availability of several different but equally valuable and obtainable interpersonal frameworks makes autonomy more meaningful by facilitating people's ability to choose and revise their forms of interaction with other individuals respecting diverse types of resources. Indeed, autonomy as self-authorship may be threatened not only by having too much law, rather the absence of law. The failure of property law to proactively support a sufficiently diverse range of types within a given sphere of interpersonal activity may undermine autonomy just as well. Nothing short of the robust legal edifice of structural pluralism will do if property law is to be guided by its autonomy-enhancing cues. Now, in the last few minutes of my talk, I want to turn to the second major prescription of a liberal theory of property, which is relational justice. So, a liberal property law constructs all these divergent property types in line with the injunction of interpersonal respect for self-determination. It affirms and vindicates our claims from one another to relational justice, because these claims derive from the very same notion of reciprocal respect to self-determination that underlies, as I've maintained, property's own legitimacy. both owners and non-owners should treat each other as free and equal persons, and thus respect each other not only as mere bearers of a generic human capacity for choice, but rather as the persons they actually are. This prescription of reciprocal respect for self-determination implies that property law should strive to ensure a more or less fair relational starting point from which parties can realize their respective freedoms, which in turn means that property law cannot ignore people's relevant personal qualities as long as they are not intrinsically inimical to the ideal of relational equality. This prescription of relational justice accounts for many of the affirmative burdens owners incur as part of their responsibility to accommodate non-owners' self-determination, and it also accounts for many of the restraints on owners' power to refuse to sell or lease, or from preventing non-owners from entering their land or using their resources, which all of those obligations and restrictions and burdens are quite prevalent in property law. These burdens and limits are conventionally explained from the standpoint of overriding public commitments to values like distributive justice or democratic equality, sometimes even efficiency. And oftentimes these external considerations are indeed important and may well justify these rules. But relational justice provides a freestanding justification for these important doctrines. Moreover, because owners' authority relies on the very same foundation as relational justice, its prescriptions are internal to property and are therefore not dependent upon these contingent public concerns. I don't claim that there is a magic formula for ensuring that property's compliance with relational justice does not overwhelm owners' private authority. And if it would overwhelm, it might undermine rather than serve self-determination. As usual, in any credible autonomy-based teleological analysis, law must follow Hart's guidance that I mentioned earlier regarding the unexciting but indispensable chore of making qualitative judgments. But we can point to three important limitations of law's application of relational justice, which suggest that even before embarking on this task, there is no reason for alarm. First, some limits emerge from the nature of legal prescriptions. Certain practices, such as love or friendship, are rightfully exempt from any legal treatment, either because legal enforcement might destroy their inherent moral value, or because legal intervention might backfire by crowding out internal motivations. Second limitation. Other set of limits come from the rule of law maxim of providing effective guidance to law's addressees and thus also constraining officials' ability to exercise power. This maxim implies that law's prescriptions should be relatively clear, so as to create an intersubjective frame of reasoning that is capable of guiding participants' deliberation and behavior by minimizing resort to individualized knowledge and radically ad hoc judgments. Third, and finally, there are also limitations on the scope of relational justice that derive from within this ideal itself. The duty of reciprocal respect for self-determination is not an all-encompassing requirement to accommodate the other party. The burden it imposes cannot be excessive because it must neither undermine the autonomy of either party involved nor create interpersonal subordination between the parties. So consider, for example, the law of fair housing. Residential dwellings are understood in contemporary society as a person's paradigmatic safe haven. The home is a bastion of individual independence, shielding us from the demands of others and from the power of public authorities, while providing us with an almost sacrosanct private sphere that is a prerequisite to our personal development and autonomy. Concomitantly, decisions about inclusion and thus also exclusion regarding residential dwellings are taken to express friendship or intimacy, whose value resists legal regulation. Thus, While it may be unethical for an owner to refuse to let another into her home on grounds of religious objection, for example, society defends the owner's right to do so and conceptualizes such non-accommodative behavior as the inevitable result of our residential practices. In this context, the very point of our residential practices implies ruling out relational justice. But ownership of a residential dwelling also includes other normative powers that do not implicate owners' privacy in these ways and therefore do not exclude law's commitment to relational justice. Suppose that a person is interested in selling her dwelling or leasing it out, but refuses to accept another person as her buyer or lessee only because of that other person's religious persuasion. Or suppose that someone wishes to purchase someone else's unit in a common interest development, but the board withholds its consent to the sale on racial grounds. Because buying and leasing a dwelling implies the fact of our interdependence, they expose certain classes of people to discrimination by some homeowners and landlords. The law justifiably interferes by insisting that these interactions be consistent with the demands of relational justice. Deciding on one's residence is often a major act of self-authorship that also plays an important role in other legitimate aspects of, significant aspects of people's life, such as their work or their children's education. The requirement that the parties treat each other as substantively free and equal individuals does not undermine the point of these residential practices. Now, advocates of the traditional conception of property have some difficulties in fully capturing the indisputable objection of these discriminatory practices. Traditionalists may be able to show that even if property law is founded on the same commitment to independence and formal equality, there may be circumstances that justify stripping owners of their entitlement to exclude potential buyers. This is the case when non-owners do not have sufficient housing opportunities available to them, so that allowing owners to make their selling or renting decisions based on discriminatory considerations would make non-owners fully subject to the choices of these owners. But since in principle, private owners and landlords neither exhaust nor control the supply of residential dwellings, there is no relationship of entailment between the discriminatory practices on the part of owners and landlords and a state of dependence on the part of non-owners. Alternatively, traditionalists have suggested that duties of accommodation and anti-discrimination in the commercial sphere are justified because commercial sellers should be understood as quote-unquote quasi-state actors. Now, this view may be plausible if narrowly applied to commercial actors providing essential services and forming local monopolies, such as the early modern common carrier or today's utility companies. However, it fails when extended to all other commercial actors. Your local real estate developer is in no important sense state actor or public servant, not even a quasi one. Many critics of the public-private distinction, the critics, for example, and scholars indifferent to it, lawyer economists, for example, reach surprisingly similar and unsurprisingly disappointing conclusions. These scholars are bound to treat the identity of the agent responsible for eliminating discrimination in selling or renting residential dwellings solely a matter of institutional design. For them, what matters is that at the retail level, members of groups that are discriminated against must enjoy fair equality of opportunity in their efforts to buy or rent dwellings they prefer, and on the wholesale level, that residential dwellings be sufficiently integrative. Relational justice, by contrast, prescribes that the prohibition against obvious discrimination by private owners is not contingent in this way. It does not depend on the extent to which the state carries out its responsibility to eliminate racial or other forms of injustices in the context of residential dwellings, or other contexts for that matter. Refusing to consider a would-be buyer on racial or other discriminatory grounds fails to respect this person on her own terms, and so does not treat her as a free and equal individual, irrespective of what the state does or does not. Relationally just terms of interaction between persons engaging in the context of buying or renting residential dwellings mandate that owners and landlords set aside certain considerations, such as their racist preferences, when making selling or renting decisions. In order for the involved parties to relate as free and equal individuals, the would-be buyer should not bear the consequences of adverse assumptions that owners assign to her based on her on the personal qualities she possesses or is perceived as possessing. Regardless of whether the state supplies sufficient housing options while sustaining integrity of residential communities or not, property law must not live intact and thereby authorize social relationships that violate the equal standing and the autonomy of the person subjected to discrimination. There is just no way around this imperative to establish relationally just terms of interaction among persons engaging in buying and renting residential dwellings. The various pieces of fair housing legislation properly implement this prescription by prohibiting discrimination in the sale or rental of residential dwellings based on such considerations as race, gender, nationality, religion, disability, familial status, and sexual orientation. The irreducible relational justice of such discriminatory practices highlights the difficulty that plugs the famous American case of Shelley v. Kramer. In that case, the US Supreme Court decided that judicial enforcement of racially restrictive covenants is unconstitutional because it implicates courts in endorsing racial discrimination. And in this way, it seemed to suggest that these covenants are not void, which is to say, racial covenants can be, according to what is implied, privately enforced, or they can be enforced indirectly through courts by suing the seller instead of the buyer for breach of contract. But racial covenants do not only violate the 14th Amendment's Equal Protection Clause, which regulates the relationship between the state acting through the courts and the persons excluded by such covenants. Racial covenants are also an obvious violation of property's relational justice. Private owners must set aside certain considerations, such as racist preferences, not only in support of the state's effort to fulfill its duty towards would-be victims of discrimination. Rather, property's commitment to relational justice offers a freestanding justification for this demand. This justification neither fulfills nor supplants the state's obligation to curb discrimination in the housing market, but rather stands on its own distinctive ground. Therefore, racially restrictive covenants should be deemed void per se, irrespective of whether their enforcement is pursued through the courts or not. Okay, I think I talked enough. Thanks so much for your patience, and I'm looking forward to your comments, suggestions, and critique.